So good afternoon or good morning, depending on where you are. My first question is, can people hear me? Okay, that's good. So appropriately enough, I think two of us, myself and Steve Finizio, are joining virtually, and not just virtually, we're joining with less than optimal virtual connections. So this may prove some of the points that we discussed during this session. Let me just start with a bit of scene setting and then introduce our panelists. And my goal here for this panel is to have a free-flowing, fun discussion about virtual hearings, which is something that I know all of us are discussing and trading our war stories about. So this isn't going to be overly choreographed or prescriptive, and I'm hoping instead just to have a free-flowing discussion amongst the participants about the pros and cons and future of virtual hearings. So I'll start with a story. This was from January of 2020. One of our panelists, Shovik, and I were in India for meetings, and this was right before COVID lockdowns started happening. People were just beginning to hear about this virus, and some people were wearing masks on airplanes. And we were in India meeting with some Indian law firms and clients. And I remember we met with this one law firm where there's this incredibly over-eager associate, really into international arbitration law. And he was so excited that he was working on a couple of articles, and they were all about virtual online hearings. And I remember sitting there listening to him, and we went out, and I said to Shovik, well, I mean, that's nonsense. This whole, online virtual hearing thing, he's, barking up a crazy tree. I'm glad he has so much energy and excitement, but what a ridiculous topic. And then, fast forward a couple of months, and we started getting requests in our cases for virtual hearings. But the justification was that this was needed as a response to the exigent circumstances of the COVID pandemic. So it was sort of an emergency stopgap measure in light of the pandemic. And I thought most of my hearings would be canceled. In fact, they weren't canceled, and they all went forward. Some of them were very rocky and didn't go so well, and others were extremely smooth. But it now seems in a very short period of time, from early 2020 until now, that virtual hearings have become accepted and commonplace in international arbitration. So the question that I want to tee up for the panel today is, to what extent are virtual hearings going to replace live hearings in international arbitration in the post-COVID world, assuming there will be a post-COVID world? So that's the subject of discussion. We've got an amazing panel to discuss it. Just very quick introductions, because I think most of these people are known to those in the room. We have Sarah Bassani, who is a recent new member to the panel. So thank you, Sarah. Sarah's co-head of international arbitration at CMS and is counsel in arbitrations and also sits as arbitrator. So I think can give us both of those perspectives. Steve Finizio, my former colleague, who is joining us, I think, from Moscow virtually, is a partner in international arbitration at WilmerHale. Like Sarah, he also sits as arbitrator and acts as counsel. And Steve has written about the subject of virtual hearings, which I think will make this discussion particularly interesting. And if people want to follow up, they can look at what Steve has said in writing on these subjects. Tim Foden, again, I think most of you know Tim. He has, I would say, single-handedly almost built Lelieve's London international arbitration practice into a force to be reckoned with. He's a partner at Lelieve, does both investor state and commercial arbitrations. Julian Howes is the Director of Business Development at the International Arbitration Center on Fleet Street, and for many, many years was associated with Brick Court Chambers before that. And Shovik Bhattacharya is a colleague of mine at King & Spalding in London. So with those introductions, why don't we get started? I'm just going to throw out, a couple of questions, and we'll see how the conversation goes, but anybody should feel free to jump in here. I guess my first question is, what has your experience been with virtual hearings today? Have those experiences been good? Have they been bad? Have they been mixed? And if you've got any good war stories to tell to illustrate your answers, please feel free to do so. So who would like to start off?
So can everybody hear me? I don't have that many great stories in terms of hearings because I got all of those experiences out with my naked 3-year-old and our pandemic puppy kind of early on. So prior to the virtual hearing, I realized I could never have a virtual hearing in my home and rented a separate space. But I think Tim just mentioned he's got some stories. So I'm gonna pass it over to Tim for the war story.
Does that work? Yeah? You really put me on the spot. Look, we had a pre-call about this, and it was very quick to see that that call could have devolved into hours-long stories of everyone sharing the technological glitches, the snafus, the rude behavior by arbitrators, and there's lots of them. I think we are all experiencing this anew. I think what I have found to be a bit surprising, but not if you take a step back and look at the way that technology has developed, not just in arbitration, but in general, shouldn't be surprising, is the way that people can be really imperious in a virtual setting in a way that they might not be if they were in person, which is, of course, what we all know about comment sections in The Guardian, for instance. People, the internet will make someone who's perfectly normal say the rudest thing because they're protected via this screen. So I've had arbitrators stop me in mid-submission and demand that I look directly at the camera instead of at the square in which I could see their face, which is obviously a bit problematic because you want to see the reactions that you get from your counsel. I've had arbitrators, when put to them with a proposition that we use my colleague Julian's services for a virtual hearing at the IAC with an agreement of the parties, a better price, say, no, we're going to use the other one. You just have to deal with it, And not only that, I'm going to have you get Opus. I want you to pay for all the hosting requirements that come with Opus so that I can go through the record. And, the costs of this facility shot up massively as a consequence. And I think that is something that we will discuss in this panel, the fact that all of these cost savings that we identify with a virtual environment might be illusory. And then, of course, there are the issues of sort of the conduct of witnesses afar. Now, I know that some of our panelists can discuss instances of, coaching and things like that. But I was involved in a hearing in which a witness just had an utterly bizarre interaction with the sort of minder who was in the room about, the witness just started talking to this person when advised not to do so, of course, and showed that person some cash that they had in their pocket. And then there was this idea that perhaps they were trying to influence the minder, which I don't know how that would have worked or what influence this junior associate at a law firm in the former Soviet Union could have exerted in the proceedings. But of course, the tribunal, which was led by a relatively eminent human rights lawyer, lost the plot. And it was all about a duty of care. And I made the grave error of saying, well, look, it's a very strange interaction, and I apologize that the witness did undertake this strange interaction, but I don't, even our opposition isn't saying that there's any actual suggestion of poor influence here or ability to, or desire to sort of change proceedings. And whew, that was a mistake. I shouldn't have been sticking up for my client because this arbitrator absolutely spit roasted me. And funnily enough, I see that person on the school run twice a week now. And the first time I saw him, I had my twins hand in hand, and this look came on his face like, oh my God, this person has children. And I just completely, well, I won't get into what happened. But these are the sort of interactions that, maybe that would happen in a live environment. We all know that sometimes the sequestration process with witnesses, particularly overnight, can get a bit tricky. You know, I saw them at the bar at the hotel and things like that, but not like this. Not where you've got, you know, a webcam set up in some far-flung part of the world and someone who's just there to watch them for hours on end. Weird things are bound to happen, and I think that the experience has been bizarre. I mean, and just personally, I didn't get into the law to be a virtual hearing room lawyer. I wanted to be a trial lawyer, a hearing room lawyer, and that sort of the fun and enjoyment and electricity just simply doesn't come when you've got 6 computer screens sat up in a conference room and everyone's looking at them with headphones on. It's disorientating, to say the least.
I guess I'll bring the sunshine to the room, because Tim took us to some really dark places. Well, you know, as with all things, when things go wrong at a hearing, any hearing, they all go wrong at the same time, and I think the same thing happens at virtual hearings. And so that's why Julian and you know, the IAC and services like that are so essential. But at the same time, things can go really smoothly at hearings, and I know that we I hope have all had experiences where things went better than they may have gone at you know, in-person hearings. Some things were more convenient. At least I think in general, everyone is coming to a consensus that for procedural stuff, where maybe there isn't a witness involved, it doesn't make that much sense for everyone to fly halfway across the world and stay for a 2-hour hearing where you discuss the timetable and maybe some objections over bifurcation very briefly. Overall, in the round, I don't know that it's been all that bad. Of course, there are things that need to be ironed out, worked out, and we will discuss that today. But I just wanted to insert a note of sunshine.
Well, I'll bring it back to darkness.
Can I introduce?
We had a situation some while ago where we were asked to, sorry, first thing I should say is I need to correct Tim. We've never knowingly undercut the IDRC, and that's very important to state. But we had a situation where we were asked to put an invigilator into a room with a Chinese witness just giving evidence to China. And not a problem at all, and the invigilator asked for the mobile phone of the witness, which was handed over. And I was reminded of a situation I had with my daughter many years ago when she was in her teens, and my wife and I broached the idea of the possibility of her handing in her phone of an evening at 8 o'clock rather than her being on that phone on the internet until midnight. And rather surprisingly, she agreed, and 8 o'clock that evening she came down, the phone, computer left on the dining room table, not a problem at all, this continued. And typically it took us 6 weeks to work out that what she was giving us wasn't a mobile phone, it's a dummy mobile phone in a mobile phone case. And to get back to the story, at the end of the evidence given by the witness, he was emptying his pockets when he was getting a coffee and produced 3 other mobile phones at the same time. So I guess the question for us is, are what we're getting what we think we're getting? And do we get a benefit? Obviously, there is a benefit from the fact everyone can continue business with a virtual hearing. But is it the benefit we actually want? And is it the benefit we're going to see going forward? I think the question needs to be thrown open that in 2-3 years' time, do we see full, lengthy virtual hearings taking place? Or are we going to see more of a hybrid that's maybe just your witnesses coming online and the evidence everyone wants to hear is actually done in person?
Steve, did you want to say something?
Yeah, and I think what we're illustrating right now is some of the technical glitches. My hand's been up since middle of Foden, but of course I couldn't break in, and that's one of the things we have to work through when we're doing virtual hearings is how do we deal with people talking at the same time. I'm also embodying the glitch. I have 2 different devices going right now. I can hear myself on the iPad that I have to look at over here. You guys are over here. My laptop is carefully balanced on 3 water glasses, so it's not really low. I've got a Kod Kandinsky in the wall behind me that is creating an impression that may or may not be the impression I want to make. So these are the things we have to deal with. But in terms of war stories, I'm going to come out both more positive about virtual hearings or remote hearings as we go along. But in terms of war stories, I think the two that come to mind for me are an early hearing in which the lead arbitrator couldn't figure out how to get rid of the image of a person who was one of the representatives of a party who had no speaking role. And we spent probably 45 minutes trying to get this person's face off of the main screen with an increasingly frustrated lead arbitrator. But I also think as we get used to the technology, this is all going to get easier. I've also had cases where parties have just been really not mindful of what they're projecting when they're not talking, including some pretty bad behavior, disrespecting the tribunal or the witnesses. And I think, of course, it should be obvious, but the number of times we're seeing this suggests that people really have not paid attention to the fact that you're on camera, and you're on camera the whole time, and you may be in a closer up than you are when you're sitting behind a table in a big hearing room. I'm also hearing myself twice now, so I'm going to stop talking and let you guys take over again.
There were a number of issues, I think, that were raised in that discussion, and there's three that jumped out at me that I'd like to follow up on. Maybe we can take them sequentially. One is, do virtual hearings really save costs? I think that's one of the big supposed pros of virtual hearings, but is that true? Secondly, do virtual hearings increase the possibility of cheating or fraud? And thirdly, if virtual hearings are the wave of the future, are they going to look like they look now? That is, are they going to be sort of the mirror image, the virtual image of a typical merits hearing? Or might they look different? Might they be more asynchronous and take some sort of different form? So let's start with costs. So one of the big arguments in favor of virtual hearings is, well, it saves costs. People don't have to pay for, everybody to fly to a foreign country and, get hotels and bring photocopiers and so on. All of these overhead costs can be eliminated. Now, I have had some virtual hearings where I'm not sure if the cost savings really materialized, because I'm thinking of one in particular, a tribunal that we had a week-long hearing, and then the tribunal said, well, there's a couple of issues that we'd like to hear more on, and since we're all doing this virtually, why don't we just have another virtual session in a month, and we can just come back and do it again? So we came back and we did it again, and the tribunal then said, okay, that's great, but I think we'd still like to hear more about this, so let's do another virtual session. And I don't think that would have happened if we were in person, and that did increase costs quite significantly. So I throw it out to you. Let's start with costs. Do virtual hearings save costs? Would you advise your clients to consider a virtual hearing in order to save costs, or is that just an urban legend?
I'll start out here. I know, Tim, you might have different feelings than I do, but I think in the vast majority of cases, it has saved a great deal of costs. When you think about the things that we used to fly across the world for, a 2-hour meeting with a client or a witness, and, these procedural hearings. I just can't imagine that you'd spend the money doing that anymore. In addition to financial costs, there's also, I have to give a plug out for the Green Committee, but there's a huge environmental footprint that goes along with those long haul flights. And by doing things virtually, I think there has and can be a potential for great savings. I would say the points that you raised, Ken, are good ones, and because it's virtual, I think people do approach it a little less formal than they would in other circumstances. But I think if you've got good arbitrators, what they can do is really head that off from the very beginning. I think more so than regular hearings, you need a lot of preparation in the beginning, including a very solid virtual hearing protocol. So you know exactly who is responsible for the technology on each side, who's responsible if the technology goes wrong in terms of cost and delay, having a dry run ahead of time to make sure that all the technology is working. And what I find is quite helpful in the virtual setting is that if the tribunal, this is something I typically do, if there are particular questions that I'm interested in as arbitrator, I'd like to give those or ask the parties, would they like those ahead of time? so they can make sure they address those. And I think all the English people in the room will love the next comment, which is I think skeleton arguments actually are quite helpful in this context, because I think it does keep the tribunal, they're people like everyone else. Their attention tends to wane a bit more virtually. It keeps them focused. So I think there are measures you can take ahead of time to try to ensure that it does go efficiently. And I think if that happens, there can be a great deal of cost savings.
What are you looking at me for?
I think there's an interesting cost savings because obviously we touched on the green aspect and we've touched on the fact that people don't need to spend an awful lot of money flying elsewhere. What we've seen at the IAC, rather interestingly, is more people attending online than attending in person. So is the client getting a saving from that aspect if they've got double the legal team per side than they would normally have? Other aspects you've got to consider is the way that the work is put together, certainly from our perspective. We would have, pre-COVID, would have been in a situation whereby someone would get an arbitration up and running and they would phone us or another arbitral centre and book maybe a year in advance. That doesn't happen anymore because there's an uncertainty about what's going to happen, because people can always fall back on the aspect that if they can't find a venue, they'll go in some way virtual. So the world is changing, and it's going to continue to change. The cost saving will be there, but are the costs being spent elsewhere? That would be my question.
I think this is the exact point. And we've seen a number of cases where the costs have gone way up because of the sort of scheduling issues that Ken alluded to. At the same time, Sarah's point is right. As we've learned that can happen, I think we learn how to react to that. So if we're going to have shorter hearing days because of attention span and things like that, or time zone differences, we have to think about how the impact is on the overall hearing days, which is where I think you drive a lot of costs that can swallow the savings on hotels and flights. But we know that as we're learning. And so we can take that into account, but there's no doubt that we've had a number of cases where the overall costs have gone up because of the use of remote hearings. Because it's that splintering into multiple sessions. It is the longer number of days or more days to make up for shorter days, and those sorts of things. At the same time, I will come back to this later. I want to come back to this idea of the privilege we're talking about here, because we're generally talking about large, complex cases. And one of the things that we have to talk about, and Ken, this is why your story at the beginning sort of can be seen through a different light. There are places in the world where our growing comfort with using video conferencing to do hearings will open up arbitration to lots of people who can't afford to do the sort of arbitrations that we do, because they're too far apart, they're too spread out, the cases are too small, and we do need to think about that part, where the sort of cost savings that do come with this may make arbitration available in ways that it hasn't been previously.
Let's turn to the second question that I think came from Tim's comments, which is the possibility of cheating and fraud. What do you guys think? Is it increased during virtual hearings? I mean, I can give you one anecdote. I had a case where a witness was testifying. The witness was supposed to testify at the arbitral institution center in the relevant country. He said beforehand, oh, someone in my family has COVID. Because of that, I can't go to the center and I must quarantine, so I have to testify at home. And nobody can come and sort of supervise my testimony because it's a COVID risk for them to come into my flat. And in the middle of his testimony, you could hear in the background someone coaching and providing answers. So does virtual hearings increase things like that as opposed to in-person hearings? Or are these just sort of the growing pains that will be ironed out as virtual hearings get more professional and popular?
Well, I think there can be a lot of precautions that you can take to make sure that doesn't happen. I know whenever I sit, you can have a 360 camera. You can make sure that the witness is very clear about exactly what the rules are. So there's no electronics. There can be no notes. Make them take the camera around and to the desk, to the room, make sure you know what's happening, and so I think there is a lot of vigilance ahead of time. And I know I always make the parties agree to that, sign statements to that effect, and ensure that the witnesses are always instructed of that ahead of time. One situation that I found a bit tricky. I was sitting as arbitrator where the witnesses were testifying in Bahasa, and the translation was taking a really long time. I mean, crazy long. So, the statement might have been a 2-sentence statement, and it would go on for minutes and minutes. And I could tell the other side was getting very uncomfortable about what was being said in the course of this translation. And so it's instances, and a few times I had to break in and say, can you please only limit the translation to the precise words that counsel is using, where I think, she was honestly trying to explain the context of things. That's what was happening. But of course, if there had been a challenge on that, we could have looked at the recording and found out if there was any information that was being relayed. But as someone who doesn't speak that language, it was a bit difficult because you knew something shouldn't take that long. And I mean, it was long. It wasn't like a minute. It was like 10 minutes. And you're like, oh, how, in what world can those 2 sentences take that long to explain? So I think there are instances where that happens, but I think if everybody's on the same board, and ultimately I'm sure what has happened is, the client you mentioned that was being coached, well, their credibility is out the window, and it's going to hurt the party who's going to try to play those games more than it's going to help them. I tend to think that these things do get exposed, especially if everyone's being very vigilant about where people are looking and what's happening and what the room setup is.
And to be fair, I think that, there are just as many opportunities for skullduggery in physical hearings, and there always have been. I mean, we're talking about an industry in which I've on 2 occasions had to have our war room debugged. I mean, what are we doing for a living when you have to bring in these ex-spooks to sweep for bugs in your hearing rooms? And that can happen in person, but I think one of the things that we're missing with this question is, what about our ability to, get up to hijinks as counsel too, which I think we don't necessarily get to do as easily in a virtual hearing setting. When you're arguing with the tribunal as to why you want your hearing to be in person, you're never going to say, well, I want to intimidate the witness. But that's exactly what you want to do, right? I mean, I trained with a guy. Well, that's true. You want to be looking that person eye to eye and say, I know you. If you go off script here, I'm going to be able to call you out on it. And I want you to feel that. I mean, I worked for years for this guy who was 6'8", named Stephen Yagish. And I'll be damned if Stephen didn't, use his hulking frame to impose his will upon witnesses. Now, I don't have that frame, but I'm angry sounding and from Philadelphia and can apply that as I need to. And also, just the ability to sort of use that one look of exasperation when the witness is evading your questions. You're not going to get that in a sort of virtual setting. And these are the tricks of the trade. Now, obviously, you want to use them judiciously, but you don't get to use them at all in a hearing setting, virtual setting. If anything, even just the sort of look of exasperation, if it's at all audible, you'll get smacked down by a tribunal member for crosstalk now. So, it's all these sorts of things that we learned as advocates, perhaps we need to unlearn now, that I don't think you get to necessarily do. And in fact, I did a hearing against Stephen Yagish in February of this year. And he was completely exasperated by the process. And you could tell, and it was great for us. Our witnesses didn't get to look down at this lumbering figure who towered over them. But, I think that we develop certain skills and they're neutered by the virtual experience.
So in my continuing role as contrarian, I think there might be some advantages to being in different spaces, aside from the cheating, which, I agree with. There are advantages, I think, to the witness being in a space where he or she has this illusion of control where, they think, oh, I'm quite relaxed here. And just to give you an example, Will Hooker, who you heard from earlier today, was doing this fantastic cross-examination October last year. 10 minutes into the cross-examination of this fact witness, there was a thin wisp of smoke starting up on the left side of the screen, and that thin wisp slowly evolved into full-on plumes of smoke, and so the witness was very soon framed by very dramatic smoke, so he would kind of lean in to give his answers. And the more he continued to chain smoke, the more relaxed he got, the more answers he just gave. And so, Will would very much just sit back and let this man talk his heart out, and we got great testimony. And so, yes, you don't get to use some of the skills that have been neutered, but there are other ways in which this could work to your advantage. Similarly, for somewhat young counsel starting out in the during cross-examinations, I think virtual hearings can be really great. You don't have to deal with any of the eye rolling from the other side. The same way that the witness is not being put under pressure by being in the same room, you're not being put under the same kind of pressure. You don't have to deal with the sniggering, the snide remarks that, the other side thinks you cannot hear but are definitely designed for you. There's a different level of comfort and control that can also be played with. And I know that others will probably disagree with that, but I think we can all agree on one thing: tell your witnesses not to chain smoke during their testimony.
Steve?
I mean, the interesting aspect of this is...
I guess my 2 cents on this... Oh, go ahead, Julia. I keep cutting you off. Why don't you go first, and then I'll follow you.
Yeah. Well, I was going to say the interesting aspect of it is that, of course, advocacy has always been theatre. And I think any advocate has, in the past, honed their skills to do their very best in court, particularly on cross-examination. And there must be an argument, surely, that a virtual hearing will dumb down that advocacy to a degree. Not least because, and it's been used in court in the past, where there is a slowing up of tactics. As Sarah mentioned, you can have a scenario whereby the consecutive translation is slowed up and taken easy. It's very difficult for an advocate to get some foundation when that's actually occurring. So the question is, will virtual hearings actually be used as a tactic in the future when maybe a party know that they've got a very difficult argument and they don't really want their witness being exposed to an advocate?
I guess my quick 2 cents are to say, well, obviously we don't know the best cheating because that's harder to detect. I'm not hearing anyone suggest that they suspect that people have cheated with witnesses in a way that has been effective. And I think that really kind of puts that issue to a degree in context. And Sarah mentioned all the different techniques we can use to try to avoid the worst of that. And Javik's story in some ways tells the benefits, right? That letting a witness go exposed him. And so I think that's one issue. The other issue I would just say quickly is that what I'm hearing to a degree is a feeling that this is shaking us out of familiar approaches. But that can't be bad in something like international arbitration, where we have to be good at speaking to people from different backgrounds, both as witnesses, as opposing counsel, and as tribunal members. And so if we think theatrics is necessary, I would say, well, your theatrics are from one national system, and they probably aren't working that well anyway. And if you need theatrics or Hulk or some other trick to really succeed in advocacy, then you should re-examine your approach to advocacy.
There's been some discussion, I guess, about body language and theatrics in the last couple of comments. I think one issue that's talked about quite a bit with virtual hearings is cross-examination, and Shavik already touched on this. The argument that I hear sometimes goes, well, one of the most important aspects is to assess the credibility of a witness. And this is something that's much easier to do in person, when you can see that person's body language, you can see if they're sweating, you can hear the inflections in their tone of voice. And then similarly, I've heard some counsel say, I find it more difficult virtually presenting to arbitrators because, again, I don't have that immediate in-room feedback in terms of their body language and their attention. You know, I can see that they're looking off screen, but I don't know what they're doing. I don't know how to capture their attention. So I guess, how much of a concern is this? Does this really matter? Or are these also concerns that are either trivial or can be overcome?
Yeah, I mean, I think that's a really good point, and I miss that the most, especially when I'm acting as counsel. It's very difficult to see all of the arbitrators and look in all of their eyes and see if they're bored with this argument, if they're sitting on, if they're more attentive. It's very difficult to read the room virtually, not least because, they're going to be on different screens here, and then you're supposed to look over here, which is not actually at them, right? You're looking at a different camera to try to appear. I find that the worst bit about it. You're looking at a camera where you can't see them looking back at you, right? So in order for them to think your eye contact is with them, you're looking somewhere else. And then you've got a team on WhatsApp, sending you all of these comments, which are, a lot of them are irrelevant. I mean, that's one thing I think we have to do, is have a protocol for the WhatsApp chat, because like Tim was saying, when you're virtual, people say things. I mean, usually that yellow sticky note that you get as first chair in a hearing is pretty important. It's thought out. I'm only going to interrupt her cross if this is something that is really critical, make this point. Here it's like, oh my God, look at his hair. Or like, did you see, look at what he's, look what he's looking at. Is he really wearing that tie? And you're like, I think there's more of a sense of freedom. And so a lot of the WhatsApp, I mean, I can't read through 20 of those when I'm doing a cross at the same time. So I find that distracting. And I don't know I guess if someone can find a technology where you could actually have that same sense of seeing the tribunal, looking into their eyes and really telling if they're into it or not, and also the witness, because I do find that's really difficult as counsel. To cross-examination is something I miss the most, and also just, getting that immediate feedback from the tribunal.
I just want to say that I worked for a member of Chambers many years ago whose calling card was that during cross-examination he had given 3 separate individuals heart attacks over 10 years. And unsurprisingly, he didn't get a lot of trade off the back of that business. But I am thinking about a scenario we had in court many years ago when, not an arbitration, but in a commercial court hearing, where one silk in Chambers was cross-examining an individual and wasn't a particularly important individual in the case, but took him through some various proposals. All to do with where he had got his degree and whether he had enjoyed the campus and the nightlife, etc., etc. Only to then be put with the proposal that the university didn't exist and he purchased his degree, which the individual said he did not. And then the counsel said that he'd not only purchased a degree for himself last night online from the said university, but he'd also purchased a master's for his dog. Which was one of those scenarios that perhaps couldn't happen in a virtual hearing, because you will be slowed down and you will not have the intimidation that Tim talked about previously. And I think Stephen's point about whether intimidation is a good thing or not is a very important point. Does it make a difference to the way you're going to run your case? Particularly if you have a case where you're going to potentially look at one witness and attack that witness. Can you do that in a virtual hearing? Does it happen? Does it work?
I think ultimately we might not have a choice, because I brought up this very topic during lockdown with a virtual panel that I led with Lord Mance, former Supreme Court Justice of Western Australia and a former Supreme Court Justice in India. And when put out there to a man, they all said, no, we as judges never look at the temperament of the witness, because it can be misleading and all the psychology supports this. But I also thought, well, these are 3 men of a certain age for whom traveling during an epidemic probably not welcomed. And they were all extolling the virtues of virtual environment. And if that is the generation that so often comprises our tribunals, I think we're in it for a long term.
So guys, I am getting virtually a note from the organizer saying that we're running out of time in just a second. If Tom Baker is around, if there are any questions, Tom, that you would like to read, that would be great. And in the interim, I'd like to ask just one final super quick question. Can we just go around and everybody give a number? In 5 years' time, what percentage of merit hearings in complex international arbitrations do you think will be heard virtually?
And how
Who
long?
shall we start with?
5 years?
It's going to be 100%, isn't it?
No,
You don't think so?
I was going to say 50.
I was going to say 50 as well.
60, but some kind of hybrid for most of them.
Hybrid seems to be the way it's going to go. Everyone knows that you get an awful lot of expert evidence in cases that really isn't that important to the case, isn't that important to the arbitrators, and therefore you're going to have a scenario where I think that's going to go. But I think you will get a lot more in person than we have at present.
Steve, what's your vote?
Sorry, I'm getting lagging audio. I was going to say, kind of, the question is to me, hybrid is right. We will see a lot of witnesses who will have reasons not to show up, even when they can. And I also think we're going to break hearings up into issues and have a lot more of what we might see in court proceedings, where you might have a motions practice where the tribunal will hop on video to deal with issues, and we might sequence cases differently and structure cases differently more and more. Percentage-wise, I think that hybrid testimony, pretty high percentage. Fully remote hearings, I think will stay relatively low in complex cases.
Yeah. Okay. Tom, are there any questions, and do we have time for them?
Yes, we do. Thank you, Ken. We've got some great questions coming for this session, which has been really engaging. I think you all agree. And this is a brilliant one. How can tech help us make arbitration more efficient and better, rather than simply replicating what would happen in an in-person hearing?
I think that was the point I was just trying to make, which is thinking about the particularities of that case and thinking about what issues can be addressed when, and thinking about whether you can cut cases down, focus on certain issues, divide hearings up to create efficiencies.
Anyone else on that one?
I don't have an answer to how, but I think it hits on one of the gripes that we've all been talking about, is looking at 5 screens. So if there is someone, I'm in the wrong line of business to tell you how tech is going to solve this, but if someone out there can solve having to look at 5 different screens, one with the transcript running, the other with the bilingual transcript, the other with the evidence up, the other with the tribunal, and the other with your witness, please solve it, because I think that's exactly what we said we're struggling with.
And better Wi-Fi.
Well, that's a global logistical problem. Facebook might be solving it or not.
Maybe it'll be holograms in the future. Yeah.
Next one. Will virtual hearings create opportunities for practitioners in places other than the usual seats, thus increasing diversity in arbitration?
I think absolutely. I mean, I think this has really made it more accessible to everybody. Not only that, I think geographic diversity, but also age diversity. I mean, one thing that I think is quite helpful, especially in virtual hearings, is to break it up. So to have different younger advocates take on different parts of something I always like to do, but, A, to give people a shot, but B, I think tribunals are more alive and more awake if they hear different speakers. And so I think it does kind of round out who can participate and how it will be, those hearings will be broken up.
Yeah,
I also think younger people are less bothered by reading faces on small screens. They grew up with it from the time they were 3 and talking to grandma and grandpa on FaceTime on a phone.
I agree with that, and I agree with what Sarah said, but I do think, Shavik, you mentioned this. I was on a panel with Greg Falkoff, who's in the audience, a few years ago, where if, counsel in Lagos has difficulties with the connectivity, then those opportunities can be stomped out very quickly.
And we've just got time for one more question. Someone's asked, recent hearing experience suggests that counsel and witnesses are perceived as more credible if they have proper sound and lighting. What does the panel think?
Yeah, I think the BGR group just did a survey on that, and there is a unconscious bias towards people who have technical difficulties. So it's one of those things that you kind of like automatically judge if things aren't going as well. So I think that's something that arbitrators need to be aware of, conscious of, and not, give a detrimental conclusion to the case because someone's Wi-Fi didn't work.
Yeah, I mean, if we're going down that route, in addition to just sound and the Wi-Fi working, you also want to think about your camera angle. You don't want half of your head while you're doing your entire advocacy, or while you're doing your cross-examination, you're completely out of the camera, things like that. I think more
Like my
than...
mother on FaceTime.
Well,
Put it up to your
Glare on your glasses.
or yeah, both Ken and Steve.
Excellent. Any more comments online, or the delayed audio? No? Okay. Well, we've just about run out of time. What a brilliant session that was. Thank you very much to the panel, the panelists, and those present here and via Zoom. It is now time for a lunch break. We'll be due back at 10 to 2 for the next session. Thank you.